So today we'll be delving into several crucial aspects. We'll be discussing the critical provisions of the IT Act along with the DPDP by understanding the legal frameworks, as DPDP is quite a new legislation, as we all know, where we'll be focusing on safeguarding the personal data of the data subject, while IT Act deals with the electronic commerce and governance. Then we'll be discussing about the intersection and overlapping of the statutes by exploring where the law converges, and some areas are overlapping, but they also have the distinct provisions to discuss. We'll also be covering various challenges and opportunities posed by the convergence of both these acts in terms of impact on the data subject's personal information and compliance done by the various businesses and organizations to ensure the data security of these data subjects' rights. As the technology evolves, so do the challenges related to the data protection and privacy. In this part, we'll be exploring where we might expect what regarding the future legislation and how India aims to stay at the front head of global privacy standards. So this was just a brief of what we'll be talking about and what our panelists will be discussing. There will be some more to it, whatever our panelists might feel, they may go ahead with whatever they have prepared. So before delving into the questions, I would like to introduce all the three panelists to you, all of you. Firstly, Dr. Gargi Rajvanshi. I would really welcome her. So Dr. Rajvanshi is highly accomplished cybersecurity professional with a PhD in cyber laws from IIT Kharagpur and LLM from NLIU Bhopal, and holds a BA LLB degree. She has received scholarships and specialized certifications in fields like contract management, research methodology, English for technical writing, and many more. With over a decade of experience, her expertise spans cybersecurity management, data privacy, forensic audits, banking laws, and compliance management. She currently serves as in-house counsel from a prominent organization. Her previous role includes at ICSI, Yes Bank, Tata Institution of Social Sciences, and NLIU Bhopal. She had assisted SEBI and RBI in developing compliance calendars and reports for Fortune 500 companies. She has also received various prestigious awards, including Nani Palkiwala Gold Medal, and has authored numerous books, monographs, and international and national papers. We welcome you, Dr. Gargi.
Thank you very much, Paki. Thank you very much.
Now, next panelist will be Mr. Gautam Busi, who has accumulated over 40 years of industry experience in information technology and information technology enabled services, along with technology, media, entertainment, and telecommunications, business process outsourcing, finances, banking and insurance services, capital markets, healthcare, and pharmaceuticals and legal services. He has worked with major multinational corporates like Vodafone, ICICI Bank, Reliance Life, and Apollo, providing support for domestic and international operations in areas such as joint ventures, mergers, acquisitions, corporate advisory, contact management, regulatory compliance, legal research, data protection, and privacy. He also leads the practice areas related to data protection, data privacy, and emerging technologies, advising on AI, blockchain, cryptocurrencies, metaverse, IoT, and OTT platforms. Currently, he is serving as the partner to the King's Tub and Kasiga. We welcome you, Mr. Gautam Busi.
Thank you so much, Paki.
Now, for the final panelist for the day is Advocate Rajas Pingle, who's a partner at NetLogic Legal Service LLP in Pune, who has a specialization in technology, privacy, and IP law. With over 12 years of experience, he has handled cases involving data theft, cryptocurrencies, cybercrime, identity theft, and more. He has also served as a practicing lawyer at the Bombay High Court and as an adjudicating officer in Mumbai for IT and economic offense matters. He has worked with MNCs like Vodafone, ICICI Bank, and many other, assisting with joint ventures, mergers, compliance, and more. He also leads the practice area related to data protection, privacy, emerging technologies, provide advices on AI, blockchain, cryptocurrency, and other tech-related legal matters. He is also an adjunct professor at the SP Jain Global Management School and has conducted various training sessions on information technology laws, cybercrime, data protection, and privacy for various law enforcement agencies, government organizations, and financial institutions. I would like to welcome you, Advocate Rajas Pingle. Thank you for joining us.
Thank you, Paki.
So now let's start our Q&A for all of three of you. My first question would be from Advocate Rajas to you. So could you please explain the key differences between the IT Act and the DPDP Act?
Okay. Am am I audible to everyone?
Yes, yes.
See, when I started my practice back in 2011, I think IT Act was relatively just it was still in the nascent stage. I would say because came into existence in 2000, and there were some amendments made in 2008, and then thereafter substantial rules regarding reasonable security practices, intermediary guidelines came in 2011. So now it's a 23-year-old legislation, and the amount of changes that I would have wanted to see as far as Information Technology Act is concerned, considering the fast pace of technology, unfortunately, we did not get those amendments in the relevant time span. Now, the key differences, if you ask me, specifically, IT Act primarily addresses legal recognition of electronic records, and then it talks about digital signatures, including electronic signatures, and their associated aspects or regulatory aspects, to be specific. And it also talks about various types of cyber crimes. Then it has several provisions vis-a-vis cybersecurity, reasonable security practices, and procedures, and so forth. So apart from this, now uh, if we see the new intermediary guidelines of 2021, which also gave us a fair amount of idea what intermediaries need to do, and it also talks about the significant social media intermediaries, their compliances, how but they should address the complaints of their users, should appoint grievance officers, and so forth. Now, if you talk about DPDP Act specifically, it primarily focuses on personal information, right? It does not have a definition, as you have seen the act as well. It does not have the definition of sensitive personal information. Sensitive personal information definition is given under reasonable security practices and procedures under Information Technology Act. So the primary focus per se of DPDP Act is personal information, our personal data and privacy. Now, it has prescribed several norms pertaining to data collection, storage, and processing of data, sharing of data, along with the rights of data principals, obligations of data fiduciaries and data processors. So it primarily talks about that, and that is those are the key differences between the two legislations. Uh, Going forward, if you ask me, and the overlapping problems which I see right now on the ground is, let me give you a very simple example. Now, I have filed several cases for my clients before the adjudicating officer. Now, those cases were pending as far as I'm talking about Maharashtra as a case study. Now, uh, if you consider Maharashtra as a case study, those cases were pending since a long time now. Okay. Uh, as we all know that Section 46 of Information Technology Act, there is appointment for adjudicating officer, right? And that adjudicating officer is the IT secretary of every state. Now, after filing, sorry, there's some, okay. So after filing that complaint, if you see the adjudicating officer rules also, the matter should have been dealt with within the span of 4 months. It can maximum extend to 6 months. Unfortunately, these cases have been pending for so long now. And now with the DPDP Act, and if you see Section 44 of the DPDP Act also, specifically Section 44 subsection 2, now as per the provision, Section 43 capital A is going to get omitted whenever the act, uh, whenever the new rules are brought into effect, and but there will be a phase-wise manner of implementation. So my anxiety now is whatever cases which are pending before these adjudicating officers, and specifically under Section 43A. Now, once the section is omitted, now all those cases are going to be infructuous. Now, that is my biggest worry or anxiety right now, which I see, and I don't know how the government plans to uh, essentially bring out rules which is going to address this. But there are so many challenges, and this is one of the challenges which I see right now. Those are the key differences, I would say.
Thank you very much for this crisp and amazing answer. I think it's quite important and it's quite pertinent that you have actually presented an overview of what are the key differences between the IT Act and DPDP, because honestly, when even I was also reading it, I was also thinking on the same lines. Thank you very much. So, going back to Dr. Gargi, my next question is with you. Could you please help us in understanding the intersection and the overlapping of both the statutes or both the acts?
So, Pavki, before I start giving my views on the intersection and the overlapping of DPD with IT Act, so I just wanted to tell you a small story, because what I learned that stories are easy to remember and we can relate them also what we are talking about.
Perfect.
So long back, there was a king, and in the king there was a minister. So definitely, whenever there's a kingdom, or like in our offices also, some of the information is very confidential. They are meant specifically for some purpose or beneficial. Same is with the personal life. So that minister was in charge of the confidential information, and all the confidential information has to be kept confidential without getting being public. What happened that once upon a time he has shared that information with the public, and then the king came to know. So king has decided to give him a punishment of capital punishment. So that minister and other minister was also amused, saying that, sir, this is a very small mistake. No, he has just shared one confidential information which is not going to cause any loss to you. Then why are you giving capital punishment? So he told ki, okay, I have one exercise for all of you. If everybody of you is like going to get passed in that exercise, so I will excuse this person from the capital punishment. Otherwise, this person is going to get executed out of the capital punishment. So what he has done, he has written a letter. Okay, and in the letter he has written 1, 2, 3, 4, whatever information he wanted to written has written, and has taken. Now you have to take it to the cliff. Okay, and from the cliff you have to tear this letter, and you have to throw the pieces of the letter in the air. Everybody did the same. They have taken the letter, they have put the letter into pieces, they have torn the letter into pieces, and they have thrown in the air. And then the king told, now you have to go and get all the pieces back, and you have to restore that letter, and then you have to put it in my custody. Then everybody was like, king, how can we do? Because the letter was torn and the information is already in air. Now we cannot get the information. So that's when king told the importance of information, that any information, once it is out, you cannot track where the information is. Okay, that is why not in India but in other jurisdiction we have a specific law. For example, USA, do not track. So this is the importance of information. Okay, that is why whether this is IT Act or whether this is DPT. So one thing which is very common in all the laws, which is talking about the not privacy, I should say information privacy, which was basically a baseline of the judgment of Justice K.S. Puttaswamy versus Union of India, that these all they protect the information privacy, the privacy of the information. Now we're talking about the overlapping or the intersection of DPT and IT Act. So there are many challenges that we are going to face once the rules will be notified and all. But one interesting challenge that I want to share right now with all of you is Section 28 of DPT. So if you just read Section 28 of DPT, so what in brief it says? In brief, it says that this act is in addition and not in derogation with any of the law which is in force. It means that any law which is already running in the country, which is governing a specific sector or generally applicable to the people, so this act is not going to override that effect. It is only simply going to add it. In that case, whatever the protections I'm having in IT law, whatever the protection I'm having in specific laws, they're already existent, they're already going. Now there should be a matching of these information. So now with this section, it is going to make it a little difficult when we come with the enforcement. So as I told you, there are many principles, there are many sections, there are many rules which I can discuss, but considering the paucity of time, I'm only going to focus on section 43 and 43A and 43B of Information Technology Act. So when I talk about section 43A, 43B of Information Technology Act, so it says that nobody is allowed to access any computer or any data whatsoever without the permission of the owner. So I'm specifically asking my audience to please note this specific word, without the permission of the owner. Okay. And if it happens, then the authority there is the adjudication authority. Adjudication authority is going to take charge of that non-compliance, and they have a right to put you to the compensation, that you have to pay the compensation whose information got accessed without permission. Okay, this is about the adjudicating authority. Now DPD talks about that there are going to be a data privacy board, and data privacy board is going to be responsible for the compliance of the DPT. In DPT also we are talking about the consensual use of the information. So what it says, whenever you're going to use any information, you have to have a prior consent. So let's say my information has been used without my prior consent and without my permission. At that point in time, where I'm going to go? Am I going to go with the adjudicating officer, or I'm going to go with the data protection board? So as of now, the challenge is not there, because data protection board is supposed to come into existence and all. But once this will come into the existence, at that point in time, the people, the subject has to decide where they wanted to go. But yes, this is one of the challenge that is overlapping, and then definitely there'll be so many litigation. I was also listening to my learned colleague advocate Rajas. He also told that he is much worried about the litigations or the challenges or the intricacies that we have to go into the future. But yes, to resolve something, I think as a lawyer I also have a responsibility to interpret. So if you just go there, no, there's one difference which I have actually noticed in DPD and in IT Act. So DPD talks about the without the prior permission of the owner. And sorry, ICHEC talks about without the prior permission of the owner, and DPT talks about the prior consent of the user. So is there a difference between prior consent and prior permission? That's important point that we have to understand. So here permission is something, an authorization. Okay, I am authorizing something to access the data, to use the data, or something like that. This is not something out of my voluntary will or out of my voluntary consent. So somebody XYZ, let's say Paki is running a website. Paki, in the website she has launched an app. That app is going to go into my mobile phone. So once that app is getting downloaded in my mobile phone, so Paki, as the owner of the app, she has to ensure that mobile phone application is going to ask for my permission, my authorization. That usually happen whenever we download anything. Okay, this is one thing. So this is that ITX take care. And now what about the voluntary consent? Voluntary consent is something that when I am sharing an information, let's say I am applying to some college, or let's say I'm applying for some job, or let's say I wanted to get access to some software, or you say wrap around or a click around. At that point in time I have to provide some information. So I'm aware that okay, I'm giving that information. That information is going to go in the online platform. So I am giving that consent that whenever required, that as per the purpose you can use. So this is one difference which is actually very bleak, and going forward I think there are going to be so many litigations on that. And definitely as a lawyer our job is to interpret, and ultimately this is up to the judge to understand and all. But this is as per my limited understanding I wanted to say. And secondly, difference between these two interface, well, specifically that 43A and DPD I'm talking about. So 43A is basically talking about the compensation. So let's say if my information got improved, okay, so at that point in time, with or without the loss, whatever I am happening, so at that point in time the authorized officer, the authority, okay, they will be, adjudication authority will be having a right to provide a compensation, because nowhere it is talking about the penalty. It is only talking about the compensation. Whose information got compromised, they will be having a right to get compensation, and adjudication authority will be having that power to decide the quantum of the compensation depending on the loss, legal or actual loss, that data holder is going to have. But in DPG, okay, there is an exclusion of compensation. DPD is basically talking about the penalty. It talks about that if you have any obligation to comply with, at that point in time you have not complied, so any non-compliance of the DPD will result into the penalty. So basically DPT is more towards penalizing, for the non-compliances. And IT Act, when we talk about the data protection, though it's a very limited role of data protection, because IT is basically majority is handling all the IT activity, electronic transaction, whatever it is. So this is the interface and the overlapping. But definitely, once data protection board is going to get enforced, at that point in time we will understand the real challenge of the interface of working, or you should say the providing of the justice by an adjudicating authority as well as by the DPT. So this is with my limited understanding.
Thank you very much for sharing your insights on this question. Now I'll be moving to Mr. Gautam. Mr. Gautam, could you please throw some light on what are some of the opportunities and challenges posed by the convergence of the IT Act and the DPDP Act?
Sure. Thank you so much for this. To start with, let me talk about what are the opportunities that are there. Um, Let me just give back a little. 2016 is when there were these opportunities which were seen by the European Union um, to give rights to the European citizens, so that there could be some kind of a business environment that could be created. And so, as you know, the companies which are operating from European Union have certain limitations in terms of the employee force, in terms of the labor laws, in terms of the employment laws. So the environment which is there doesn't really permit them uh, to give so much of time, energy, and resources. They pass on the information to countries like India, China, Bangladesh, Pakistan, Sri Lanka, so that it is cost effective. At the same time, it kind of supports the entire business as well. So now there is something called a adequacy test which has to be passed when it comes to GDPR, and these adequacy tests are important for having a level playing ground between GDPR countries and countries like India. Uh, so now, is India qualified? Uh, has India passed the adequacy test? The answer is no. So does IT Act give an answer to that? So it's been there since 2000, and we've been providing services to companies outside India, but but still we have been considered as being adequate in law. Now, why is that? Despite 43A being there, that's predominantly because we do not have an enactment which is so-called Data Protection and Privacy Act, which should be there. So now we have DPDP, which has come into place. DPDP basically takes care of the data which is to be processed. Um, Now, this is something which is going to be evaluated by the European Commission to see whether it is something which comes within the adequacy rule or not. Right. Now, what are the opportunities that we have right now is that with the Act coming into force, now this Act is nothing but a replacement of Section 43A. Section 43A talked about reasonable security standards being there, and we have ISO standards 27001, 2, and we have 27701, which give a global assurance that if you have these regulations in place, then it is called a deemed compliance. So that was the only basis which we were actually running the entire show for India, by letting the entire information of European Union or the other informations coming from US like CCPA, CPRA, HIPAA, or even Middle East giving us information. We have African countries giving us information. We have South Asian countries giving us information and all that. So that information comes and resides in India, uh, and we needed to have some kind of an act which says that yes, this is Data Protection Act. That is where the assurance was given, and this is something like a business enabler. It's part of the entire IT Act of 2000. It should be read with the IT Act. That's why I think our learned friend who was actually mentioning that it is to be read along with that. in the entirety, which is totally true. So to say, in fact, IT Act, it has all the hands, legs, and teeth to ensure the enforcement of data is there. So how it happens is, IT Act under IT Act talks about breach of confidentiality, talks about privacy. It actually says that it's above 2 years imprisonment or fine will be imposed if anything which is leading to breach of confidentiality and privacy. You have data theft, data fraud, and hacking, where in anything which is causing that, anyone causing that can imprisonment will be imposed up to 3 years and a fine of 5 lakhs. Then you have interception of monitoring of computer systems, where you have imprisonment up to 7 years and fine. Now, even interestingly, Companies Act also says this. So it's more like lifting the corporate veil to figure out what are the punishments for fraud that you do. So if you do any kind of fraud, then there's an imprisonment up to 6 months and a fine which is 3x of the fraud amount. Then you have punishment for any false and misleading statements and any kind of omissions that you make. So even for that, there's an imprisonment of 6 months and a fine of 50,000 up to 5 lakhs. Then you have punishment for suppressing material facts with the intent to deceive others. Now this is 6 months to 3 years, and also a fine up to 5 lakhs. I think these are something which are already there in place. IT Act is quite robust, and if you're talking about the confluence and convergence of IT Act with DPP, I think this is already there in place. So data, actually to say, is one of the elements of the entire IT Act. That is how I see it. And data is very important to us because it is a constitutional right. It's part of right to life, as rightly pointed out in Pudduswamy judgment. So so wherever the English citizen travels, the Constitution of India, with its rights of right to life, will continue to be there. Now, saying so, I would like to take you through certain provisions which are there, like Section 3B of DPDP Act talks about applicability of the Act being having extraterritorial jurisdiction. Now, if you see that alongside with Section 75 of IT Act, it says even that has an extraterritorial jurisdiction, and it actually specifically says that any data breach which is outside India which is committed using India computer system in India is an offense. Section 4.3 of the IPC refers to jurisdiction of Indian court, which can try cyber offenses which are committed outside India. Then we have Section 188 of CRPC, which talk about any criminal offense which is committed outside India, and it can be tried and any inquiry can be conducted within the jurisdiction of India. And in case of any offense which is committed by the government of India, then of course this is something which is debatable, because that is something which is still a gray area, because the Act doesn't talk about it right now. But as I see it, if it's a violation of Section 21, then of course there's a writ which lies, and the citizens of India can definitely move against the government of India for any kind of violation that happens which is affecting their right to life. As I see it, I think it's a very robust environment where which is a business enabler for internationally let the business come into India. Now, what are the challenges that we have here is very surprisingly, we don't have an element of compensation which was there earlier in the SPDI rules of 2011. I think if there's something like if Paki's information is lost, then I think rightfully she deserves a compensation. But the compensation fact which was there in SPDI rules of 2011 is missing right now. So I think that is something which the government needs to work around and make sure that the compensatory factors are also made part of the DPDP Act. And as far as certain suggestions for the improvement of this enactment is concerned, I think India, though, is falling behind. I think there are certain facts like data portability that needs to be addressed, which essentially means that if I have to transfer my services from, say, ICICI Bank to HDFC, that kind of enabling factor should be there. So that the data can be transferred. But then certain challenges to that also, because we are the innate systemic problems that we have, and India still has that problem with uh, human beings, so to say, because humans happen to be the weakest link in data security, as we all know. So how to plug that issue is something which is a very tricky issue, though we may have systemic controls in place, which includes technology, organization measures, and managerial measures and all that in place, which are, I think, repeatedly mentioned across the globe in most of the legislations to be there. But still, I think that's still something which is very difficult to implement in India. I think government of India definitely will look into this to have data portability as one of the aspects to be covered. uh, then I think IT Act also includes a certain other regulations like banking regulations. I mean, if I have to, I wouldn't speak too much on that because of the paucity of time. But there are certain areas which are covered, like banking regulations. You have SBI Act, you have banking companies transfer of acquisition of undertaking Act, then Credit Information Companies Act, then you have medicine and healthcare enactments which are there, insurance, right to information, Aadhaar. All these are kind of connected to IT Act. I think that is quite robust that way. I think though we kind of are in criticism to of Indian enactment, that it is not covering all aspects, but it is so large that it covers most of the aspects which need to be connected. It's just that you have an IT Act and DPDP gets connected. Then you have all the acts which are relating to healthcare, finance, all the things that we talk about SPDI. The entire regulatory frameworks are all aligned to IT Act. In fact, so much to say, you have certain regulatory notification circulars which are passed by TRI, you have RBI, you have IRDA, PFRDA, and many other regulations, even in healthcare sector, which have passed notification circulars saying that data needs to be completely safe. And in their own regulatory framework, they have said that data needs to be completely safe and secure according to the standards that they have prescribed. And interestingly, as reaction to the Puriswamy judgment, I think RBI reacted immediately and said that information should not be traveling outside India at all in any way until we have a regulatory framework in place. And the then regulatory framework, I think, was very clear, which SEBI also followed, was not to keep all the information only in India and never transfer it outside India. So government of India now um, is going to be releasing the rules. Rules are going to be specifying if at all the data has to travel outside India, then what is the manner in which it has to be done? What are the safe and secure standards that need to be followed? Plus, they're going to be issuing list of countries which are blacklisted and the ones which are listed to be transferred. So this is all from sir.
Thank you very much for answering this question in a really brief format. Thank you very much. Now, my next question is with Dr. Gargi. So, Dr. Gargi, do you think that the IT Act and the DPDP Act will impact the way business and organizations collect, use, and share the personal data?
Definitely, Paki. Rather, this is one of the game changer that now companies are supposed to comply with certain requirements. So, before I speak on this issue, I just definitely wanted to appreciate you, Paki, because if anybody can go to your LinkedIn post and all, so all the LinkedIn posts are basically focused on the data governance. So, unfortunately, in our country, data governance has come a little later, though we have come up with the IT law in 2000 only. But if you talk about the Europe, UK, and USA, so they are basically very clear about data governance. So before I speak on how the business got transformed out of or are going to transform further out of DPD Act, I want to tell you in brief what is data governance. So data governance is a method of collecting the data where data is collected as per the requirement. Data is complete as per the requirement. Data is collected as per the process which ensure the security of the data. Data is used only specific to the purposes, and once the data's purpose is over, okay, the purpose for which it's related is over or is achieved, at that point in time either it is retained in the secure manner as per the retention policy applicable to the company, or it is deleted. Okay, so this is basically data governance, and this data governance three important factor which work is definitely first is the human acumen in that. Okay, so definitely human acumen, the data belongs to which person, what is the importance of the data in the data market, and who is collecting that data, what are the people involved in the collecting that data. Second is definitely the processes, and third is the technology. So when we talk about the center data interface, so and when these all parameters are on their perfection, at that point in time we simply talk about the data governance. So this is data governance, and this data governance which was actually was not in law, now it has been put into the law. So I think everyone must be aware that the DPD Act itself was not the first draft. So there were basically three or four draft was being floated on the floor. The views were taken, and after the views, okay, this law has come. So I'll tell you why data protection and companies' interest has to be balanced. So when I talk from the perspective of the data owner, okay, my data, at that point in time, I was only wanted to ensure the protection of my data. That's all. But when I talk about from the perspective of the company, so my data is basically either a means of earning the revenue or supporting the earning of the revenue, or is a collateral to the earning of the revenue. At that point in time, the processing of the data is very well important from the company perspective. So now what company says that I want a free hand to use that data. What an individual says, no, my data cannot be used because this is my personal data. This is my asset. At that point in time, that balance has to be drawn. So to draw this balance, DPT Act has been framed in such a manner. Okay, data has to be used, but there is some parameters on which company has to ensure that data is protected. So first is definitely the notice. So whenever your data is getting collected, you will be given a due notice from the company that we are collecting the data. Okay, and now you have to give a consent for the collection of the data. Once your notice is given, then express consent. Okay, here it is talking about the express consent, though there are some integrations in the express consent, and I believe that once the rule will be coming at that point in time, we will be able to get it with clarity how the express consent is being defined or being intended by the government. Then once the consent is given, at that point in time, the purpose. Okay, so data has to be retained with accuracy and only for the purpose. Any data which is falling outside the jurisdiction of your purpose has not to be retained by the organization. After the purpose, this is the processing of the data for which you are processing. It is important that the processing is going to be secure. And the fifth principle is withdrawal or the deletion. So now with these five parameters, so company has to keep a track of it. So now I'll just put it in a very simple example. So for example, I am a customer of some HDFC bank. Okay, so I wanted to open an account. For opening the account, some of the important documents will be required. I have to share that information to the bank. So now there are two processes bank can take my information. One is in the physical form, and second is the digital form. So once it is in physical form, okay, so DPD is not applicable on me because it is simply saying digital personal data protection. So any data which is not in digital format will not fall under the purview of DPT. Okay, this is one thing. So like in the first parameter only, my information is completely in the physical format and nothing is in the digital format. So I am not under DPT. The company, the bank is not under DPT. Now, second parameter, that my data is in digital format, so definitely company has to follow that process. So what they'll do, they'll take my data, they'll process my data for the opening of the account, they'll store my data as per their retention policy. If I'm not wrong, so as per the RBI guidelines, the retention policy is for 8 years or something. Okay, they'll retain that data. During the retention, they'll ensure that my data is secured. Let's say tomorrow I wanted to close my account with HDFC Bank. At that point in time, I will be having a right to tell to HDFC Bank that, see, I have now closed my account. You have to delete my data from whatever server you have, even if you have to keep it for the compliance purposes. At that point in time, also you have to ensure that beyond that it is not capped. So definitely the compliance mechanism of the companies is getting enhanced. And apart from that, there's another thing, that now in this example only, so tomorrow let's say HDFC has hired some outsourcing service providers. At that point in time, where the HDFC will be free from the data obligation if my data is passed on to the outsourced organization? No. At that point in time, being data, at that point in time they'll just change their role. Okay, but they have to ensure that even the outsourced service providers are going to protect my data. Here, one more thing I wanted to add it from the banking perspective only, as I've already mentioned, section 38, which says that DPD is in addition and not in derogation with the existing practices. So let me tell you, as per the RBI circular, if there is any breach of any data or whatsoever, at that point in time, especially the customer data, the personal data, at that point in time, the bank is supposed to inform to RBI about the data incident within 2 to 6 hours of the data leakage. So this is already one compliance that banks are following. So what my purpose of telling is कि DPD में जो है वो तो आपको comply करना ही करना है. But apart from that, if there is any specific law which is talking about any other compliance, at that point in time you have to comply. So basically, it is the data management, the compliance management, and data governance. Now company has to by default opt for out of this DPT Act.
That's amazing. That's quite insightful. I was having a very brief idea, and I'm sure that many people are having a very basic idea about what is the collection, how it's going to process, and what the kind of impacts it will die on the data subject. Thank you very much for answering this question. Okay, so my next question is with Advocate Rajas. So, how do you see, Mr. Rajas, the IT and the DPDP Act evolving in the coming years?
Okay. I can only speculate right now as far as Information Technology Act is concerned. Either we will get further amendments to Information Technology Act. See, this is inevitable. This is going to happen. Either further amendments, or we will get a new legislation altogether in terms of information technology. And what I've been hearing is Digital India Act. So that specifically about Digital India Act, we have been hearing for so long now, and I've been following it very closely. I saw that the ministry also taking a few sessions in Bangalore, in Delhi. They also talked about, they had a entire presentation and all, talked about how the information technology law landscape is going to change in the future, and incorporating several provisions regarding AI and cybersecurity. So that kind of a change we are going to see. I don't know whether they are going to. It's still a speculation. We are going to get a new legislation altogether, or we will see a certain change in Information Technology Act. Now, in terms of the change, uh, I see the intermediary guidelines of 2021 and the amendment in 2022 are also going to change once the DPDP rules thereunder come into force, because they will have to change certain aspect of it. Because if you see the intermediary guidelines, they also talk about collection of data. They also talk about having a privacy policy in place. They also talk about having a terms of service in place, disclosure of information, and all the aspects which are already covered under the DPDP Act now. So that is bound to change. And in terms of the DPDP Act and the rules there, and what we can see is further it could evolve to strengthen data protection frameworks in terms of it will incorporate global best practices. Like, for example, if you see the Singapore's Personal Data Protection Act or GDPR, specifically all these legislations for cross-border data sharing or transfer of data, they also require the other country to have similar set of legislation in place which has the same standards as their own legislation. So in terms of that, I think we might also see certain changes in terms of these new rules. Then I think there might be some unforeseen challenges which we can't think of right now. Once the rules come into existence and we actually the enforcement of DPDP Act starts, then we will see on the ground level what are the challenges that might arise from the compliance and basically further moving forward. So I think all these things are going to or bound to change. We are not sure about the timeline, but definitely Information Technology Act is going to see a substantial amount of change in terms of either the amendment or a new legislation altogether. That's what I think.
Amazing. Thank you very much for answering this question. So now my last question is with Mr. Gautam. So Mr. Gautam, could you please share your thoughts on the futures of India's data protection and privacy regulation? What do you think, like in terms of blockchain, AI, quantum computing? There are a number of things that are going on as the technology evolves. So what's your perspective on it?
Yeah, it's pretty interesting to see that the enactment actually has come into place. Honestly, I was not really hoping that it will be actually this soon that the act will be coming into place. But yeah, of course, it's been pending for the last 16, 17 years. And, they've had very anxious times that, there were specific laws on this. But yeah, it is late, but then it is good that it's there. How I look at it is that it's 80% covering the requirements of the business and the environment, which is to do with uh, forming a very good base for guaranteeing the rights of the citizens. I think this is something which did not have the hands, legs, and teeth. So it did not have anything which was operational enough for us to have post Swami judgment. I think it was only the regulators who were taking this seriously to ensure the innocent citizens' rights are not affected. Um, so there, of course, there are certain issues which are still unanswered. As our friend here was mentioning that the rules are pending. The entire environment with respect to transfer of the data is something which is still pending. This happens to be one of the challenges. But nevertheless, see, India will have to one day align with the business requirements of the world. So if you're asking me if does it look bright for India, the answer is yes, we're going the right way. I think it's just a matter of time that we'll have to align with the laws which are already present. Couple of issues, as I was mentioning earlier, data portability is the area that we need to improve. But of course, there are some secure mechanisms that need to be there in place so that the citizens feel safe and secure with the potential issues we have. I mean, you and I daily keep getting many calls, and if that is the way it is, all this unsolicited escort is what I'm mentioning. So, if there's a data exchange which is happening already, and we are talking about data portability, I really do not know what the relevance of it is when it is already happening, but more from the illegal perspective. But looking at from the legal perspective of data portability, I think there's lots of work that needs to be done to make sure that it's safe and secure. and the current environment is something that needs to be addressed for sure. Then there are issues with respect to child rights. We need to take that very seriously because there's a lot of issues that concern with children, and I don't think those are completely covered out here. The rights of the disabled are also something which needs to be kind of looked at to be seen how we can make it more robust enough. All in all, you know, the entire industry needs to kind of become a little more robust enough to understand that they need to change their policies, they need to change their agreements. We need to have very serious appointments of consent managers. We need to have DPOs in place. Then we should have grievance redressal mechanism in place, and have all the audits and reviews done properly. I think somewhere down the line, this is something should not be taken as a burden. So I've been having a discussion with many people in the industry who feel impacted because this is something that they'll have to follow and all that. So my advice always has been that, please do not take this as something which is an additional compliance. It's something which is a responsibility of the company to do it. Though there is some kind of a cost which is involved, but ultimately in the long run you'll be making more clients because you'll be giving a assurance to your own clients, and not just India but outside India also, that you have a robust system in place, and a very strong legal compliance system in place, which will help uh, uh, the business grow, and the customer assurances which are the client assurances which are given always enhance the businesses and the confidence of the people who are wanting to invest. So yeah, so all in all, I see that this regulation, this law is quite bright, but I just would want an organic growth of this law happening, so that we see uh, this happening soon.
Great. Thank you very much for answering this question. Now I have just 2 or 3 questions left that are asked from our participants earlier. So my first question is with Dr. Gargi. So Dr. Gargi, how do you think that DPDP is better than GDPR?
Sorry, Paki, I have got some uninvited panelist in the session, but I can't help it. So, see, regarding DPD and GDPR, I'd still say that GDPR is more customized than DPD. We have a long journey to go, and I'm not going to blame it on the government or the other stakeholders or whatever it is, because the DPD has come in 2023 and GDPR has come into 2018. So all the challenges and all judicial pronouncement has come, and they have got some major or minimum amendments in their rules or their implementation policy. So for us, the journey has just started, I should say. This is one thing. And secondly, I would like to tell you that here in DPD, we're basically talking about the digital data. But GDPR, as per se, is not talking about the digital data. It is talking about all the data, whatever's covering under that GDPR. So GDPR is more comprehensive, I should say. It is providing an all-inclusive protection to the data, and for DPD, it still has a journey to go. And one more thing that I want to highlight: a major difference between GDP and GDPR and DPD. So in DPD, whatever we are saying that okay, every time some exception can be created. Okay, that this exception can be created by the central government. This exception can be created by central government. I think if I'm not wrong, so there are some 14 or 15 instances the central government may change the rule and can create the exception, wherein we are forgetting that the major processor of the data is government itself. So this is a conflict of interest when we talk about the exception. But in GDPR, this is not the case. So they have basically opted for the pigeonhole theory. Okay, so everywhere that exception or the criteria for this exception or the standards, it is being already defined. So this is as per my limited understanding. Maybe the brief comparison I might provide, if you can allow me with a PPT or a kind of a comparative analysis table.
Thank you very much. I think for now it suffices. Thank you very much for your answering the question. So, Mr. Rajas, I have one question for you as well in my kitty. So, how does the existing laws can help prevention of cyber crime, and now how AI can curb cyber crime in cyberspace?
The existing laws.
Yeah.
See, I think the existing IT Act
And the
to some
DPDP, of
extent.
course. Yeah.
I can't talk about DPDP. Once it comes into play, then we can see how it is implemented properly. But right now there is no case law, nothing, no cases at all to talk about, right? But I can talk from the perspective of Information Technology Act, being practicing in the field for the last 12 plus years now. What I can see and what I can tell you right now is the current act is uh, adequate to some extent, but when it comes to providing deterrence, if you see majority of the sections, majority of the provisions under Information Technology Act, the punishment is up to 3 years of imprisonment, right? Now, that does not ensure confidence into people that, okay, if someone is committing Information Technology Act, he will be imprisoned and and subsequently he won't commit that crime again because there are harsher punishments or there are, I mean, the years of imprisonment is so much, so higher that that person won't be thinking about committing the same crime again. Unfortunately, that is not the case. And if we see the economic crimes or the phishing attacks or the ransomware attacks, they keep on happening, right, again and again. And even if you catch these perpetrators, they tend to commit the same crime again. They what they think, and I have experience in the field. That's why I'm able to tell you and share this with you that if they are caught, for example, okay, punished, huh? If they are behind bars, for example, for 3 years now, once they come out, they are going to commit the same criminal activity again. I'm telling you this because 3 years is nothing compared to what kind of money they are minting every day. And if you have seen the documentaries, I would say the documentary only because I have seen cases of originating from Jharkhand specifically, Jamtara. So all those phishing attacks, even if you catch hold of these people, it's not going to help much as far as deterrence. So what I need in or moving forward is to increase the punishments and to increase the efficiency of Information Technology Act or the Digital in India Act in the future. Plus, uh, people would want to file these compensation suits. I don't know what kind of amendments we are looking at right now, but if you see currently, even if you file cases for compensation complaints specifically before the adjudicating officer, people are not getting I mean, they're not getting chance of hearing only, let alone getting compensation from the adjudicating officer. So that's the biggest problem which I see right now. Even if we enforce this act correctly, I think more than 50% of the problems are gone. But if you need uh, some sort of deterrence, I think amendments are required or a new act altogether is required. And even in terms of cybersecurity, because in terms of if you consider implementation of AI in cybersecurity, it is going to help a lot, and it is going to automate a lot of things. And let me tell you a simple example of it. Uh, with the incorporation of AI into antiviruses, right now what I see with what I have seen specifically at my home is even if you want to visit a particular website, and if that's a phishing website, the efficiency and the capability of that antivirus has increased so much now because it knows already if that's a phishing website or people have it, if that particular website have been flagged as okay, there's some sort of fishy thing going on in the background, it is going to inform you. So I see a lot of these new technologies helping the layman in terms of safeguarding their own personal information and sensitive personal information.
Great. Thank you very much for answering this question. I have one question for Mr. Gautam as well. So, can you please let us know that how DPDP Act is going to affect the health tech startups?
Yeah, that's a very interesting question. In fact, in healthcare, I think there have been a lot of violations which are already existing. I think we all know about that. We go to the hospital, the information is collected, and then you start getting calls just a couple of hours after that. So, if you are asking about the healthcare startups, I think see this is a very typical formula that we have for any activity which is relating to data protection, and this is something which should be in the beginning. To give you a small instance of what happened in my past, so I was reporting to Germany and UK when it came to data protection, privacy, compliances. So I was interestingly asking them, why is it that you always think of compliances when you have to come to India? So, I mean, of course, there was a little silence before they answered because they thought that I'd feel offended. I was like, you can be candid with that. And they said, we don't trust you, right? Now, the point is that we all know that we don't trust, right? So I think we have been affected for last 20 years and rather inflicted with all the unsolicited calls and all such unsolicited things happening in our life. So the best thing that should be done is to have a compliance environment before you even start the business. Somewhere down the line, I think this should be made mandatory to have a robust compliance environment, which is the entire gamut of data protection, data collection, processing, storing, sharing, and purging. The entire environment is something which should be typically going as per what is required under DPDP. DPDP, honest to say, is a very sketchy act. It only talks about the laws that need to be there and what are we supposed to adhere. But if you really look at how the entire engine runs, then I think you'll have to get to understanding how information security works, how privacy works, and one has to understand how to implement these in an organization which is having the responsibility. So it more so with the startup because they have to build the culture of privacy. In fact, everyone, be it an individual or a company, will have to have this concept called think privacy, right? So, and that is where the entire game starts from, right? So if you look at ISO standards, I think it's very, very robust for giving that level of hand holding at every stage to any organization uh, as to how to maintain safe and secure environment. I think more and more companies should look at having ISO standards because ISO standards or IEC standards have actually graduated to next levels to provide privacy securities. To answer your question specifically, what the startup healthcare should do is to think privacy. Second, take certifications of ISO so that if you don't know, ask those people what to do. Interestingly, again, startups are exempt right now till further notifications by the government of India. So, healthcare as such also is kind of exempt for almost a year because there's a huge environment that needs to be built around healthcare. So I think they are using an approach which is kind of a phased approach for having healthcare to have such kind of an environment.
Thank you very much for answering this lengthy question in such a brief manner. There's just one question left. I think one of our attendees has asked, does any of the panelists see loss with respect to data hamper the overall technology growth? As per Mr. Ashwini Vaishnav, EU is losing battle of technological advancement due to GDPR. Will the same happen to DPDP Act enforcement in India? So it's a common question from all three of you.
So, with the permission of the panel, can I reply to this question?
Please go ahead, Dr. Rajvanshi.
So, if I talking about the growth of technology, so India is at ranking 3 on the technology, information, and its growth. And also, we have already grown so far. Okay, so DPT is basically not going to grow the information, because all information is already growing, information is already flowing. So, what is the purpose of the DPT? It is going to basically regularize or basically regulate the usage of the data. So it is going to protect your data to the extent that it is not hampering the commercial interest of the industry in the country. So this is my understanding to the growth of information.
Thank you very much. Your views, Mr. Gautam and Mr. Rajas?
If you ask me, I don't think so that it is going to hamper the evolution or the growth in terms of technology, because see, we have already reached uh, at a particular time uh, that we as a country in terms of technology are doing a
ये
lot
दुनिया
in
जल तो
terms of
यही
digital
आके तो
governance,
आद्या कभी माया कब
in terms of digital governance or data governance. We have been doing that, right? But unfortunately, not all, I mean, small to medium scale companies are still catching up, but I don't think so that it is going to hamper at all. It is going to regulate. That's it.
Thank you.
Yeah, I think even I agree with that. In fact, if you look at metaverse, AI, ML, Web3, Internet of Things, or any kind of technology that you take, I think the first and foremost concern of the developers also has been to ensure that there's a proper, safe, and secure environment. I think it passes through a strict regulatory checks before it is launched into the market. There are a lot of learnings because human evolution is happening along with the new technologies which are growing along with it. If you look at many of the apps which are there on the iPhones, I'm sure you'll understand that they're also becoming privacy by design, where even if you do not provide your personal information, the app still runs, as against apps which earlier mandated that you need to have your personal information given. Metaverse also. See, I'll give you one small instance which happened with me. So, one of the tech seminars that I had gone to, of course, there were no lawyers. Um, so, I was asking them that why is it that they don't think of compliance? So, they were like, okay, it's a lawyer's job. So, what do I even think about? So, do I think about the business or do I think about compliance before I do anything? So, even though I create something, it'll have to go through a standard checks and balances of the regulators, and I think that kind of gets ironed out. And many a times we get into criticisms of the apps, merely thinking from the perspective that, oh, this is not happening, that is not happening, and we make the technology as seem like a Dracula. But I don't think that's the right approach. I think evolution is the only thing that you cannot ever stop, and I think it's very very important that the evolution should happen because it's good for the mankind. Uh, but if you're thinking that you should have safe and secure safeguards equally, I think that is also very important. But they should go hand in hand. I think the maturity lies in understanding the evolution cannot stop, but also the maturity goes along with saying that it has to be in a safe and secure environment. So if regulators are not able to give it, I think um, that is something that need to be worked on by the regulators. Um, but yeah, evolution cannot stop on this.
Thank you so much for this amazing session. And thank you so much to all three of you for joining us today and sparing your evening with us for this discussion, because it's a very crucial kind of a thing in our digital age where data is central to our lives, along with the legal frameworks which must be adapted to protect our privacy and security. We are also thankful to our attendees who joined the session this evening. We have requested you to fill out the form mandatorily in next 2 to 3 minutes to claim your certifications, and that will be mailed to you in next 7 to 10 working days. Thank you all for your active participation as well. Thank you very much to all three of you. I'm so thankful to you. Thank you.
Thank you.
Thank you, Baki, for arranging
Thank
such a nice and nice session with so much of learning on data protection.
I'm so
Thank
thankful to you, to three
And
of you,
while
because I
on the platform,
understand.
I wanted to appreciate the way you are actually creating awareness on data and data protection.
Thank
Keep
you
doing
very
good work,
much.
Baki. And thank you the other panelists also and all the attendees who have attended the session. Thank you very much.
Thank you very much. Have a great evening. Bye-bye.
Thank you so much.